today's talk radio.
KDWN News Time, 9 o'clock. For 20 years, Brian A. Lowe and Associates have helped Las Vegas locals protect against foreclosure and file Chapter 7 and 13 bankruptcy. If you're in trouble, call 259-0002. Good morning. I'm John Schaefer with this hour's top stories. Troubled Nevada state lawmaker, Democrat Stephen Brooks of North Las Vegas, has been banned from the legislature and placed on paid leave while an independent investigation into his recent behavior is conducted. Lawmakers took the action yesterday. It follows his arrest on Sunday after his wife called 911 to report a domestic disturbance. An attorney pleaded not guilty on behalf of a University of California, Berkeley law student who's facing felony animal torture and killing charges in the beheading last October of an exotic bird at the Flamingo. The attorney says 24-year-old Justin Alexander Teixeira intends to fight the charges stemming from the October 12th decapitation of the helmeted guinea fowl in a wildlife habitat exhibit at the resort. Raising the curtain on his second-term agenda, President Obama set to deliver a State of the Union speech tonight that puts the focus squarely on the economy and jobs.
The President of the United States.
It's the President's fourth State of the Union speech, and aides say it'll flesh out themes from his inaugural address just 3 weeks ago.
Bottom line is this, people, we got a lot of work to do.
Starting with things to shift the recovery into high gear.
What we need to do to make our economy work for the middle class.
Press Secretary Jay Carney says with all the talk of immigration and gun violence, job creation will get top billing tonight, along with a plea to Congress to avoid another job-threatening showdown over the deficit. Mark Smith at the White House.
A veteran Nevada judge has apologized after a disciplinary panel agreed to issue a public reprimand because she kept an irregular court schedule during a 2010 trial. It included leaving early on several occasions to attend her daughter's soccer games. Clark County District Court Judge Valerie Vega admitted that she was discourteous to jurors, lawyers, and court officials by keeping a jury deliberating all night at the end of a 6-week trial so she could go on vacation. The United Nations Security Council has been called to an emergency session this morning to deal with North Korea's latest nuclear test.
Former U.S. Ambassador Christopher Hill says the world needs to step up pressure for the North to quit doing this sort of thing.
We need to, make sure the Chinese, who have been really unwilling to do things in recent years, we need to really get them to work on this.
Korean military expert Cedric Layton says he's on board with that idea.
Are they willing to do that to the extent that it would be necessary to prevent the North Koreans from further developing the nuclear arsenal?
The emergency meeting takes place ahead of an already scheduled Security Council meeting. I'm Shirley Smith.
An 81-year-old Henderson man is among 7 suspects indicted by a federal grand jury on charges of growing marijuana. The indictment says the suspects grew more than 100 pot plants at 3 different houses in Henderson and Las Vegas. The other suspects range in age from 29 to 64. The financial report brought to you by Las Vegas jewelry and coin buyers. On Wall Street, the Dow's up 29 points. Gold is at $16.51 an ounce. Silver $30.99. Platinum $17.04 and palladium $7.69. For questions about your precious metal or coins, call 547-1670. News brought to you by Starbucks Via. Between the snooze button and the shower, or crunch time and meeting time, with Starbucks Via, there's always time for Starbucks. Just add hot water, stir, and enjoy. Look for Starbucks Via where you buy groceries. It's 9:03. Here's Mitch Kelly with the latest from the KDWN Nevada Credit Union Traffic Center.
This update brought to you by Firestone Complete Auto Care. Renew your ride with a new set of tires during Firestone Complete Auto Care's February tire event. This month, buy 3 and get the 4th free on Firestone Champion HR high-performance tires for your vehicle. Call 1-800-LOCATE-US to find the store nearest you. Together, Firestone will keep your car running newer, longer. Got a right lane blocked on 95 northbound because of an accident at Boulder Highway, but because of the hour of the day, we're not seeing any slowdowns there. But again, that's 95 northbound at Boulder Highway with a right lane blocked. A pair of Southern Beltway accidents, westbound approaching Windmill, eastbound at Warm Springs, both off on the left shoulder. Service Street accidents, the most serious one near the Silverton, Blue Diamond at Dean Martin Drive, west side Rainbow south of US 95 at Westcliff, and a pair in the southeast, Maryland Parkway at Windmill, Pecos at Russell. From the KDWN Nevada Credit Union Traffic Center, I'm Mitch Kelly on News Talk 720 KDWN.
The KDWN forecast: sunshine today, 57 the high, clear 39 overnight, then sunny and 63 on Wednesday. Right now, sunshine, 41 in Las Vegas. Your next update at 9:30 or when news breaks, and we're always streaming online at KDWN.com. Brought to you by Brian A. Lowe and Associates. I'm John Schaefer, News Talk 720 KDWN.
Hey there, it's your pal Rusty Humphreys. You know, the business environment is tough everywhere, but especially here in Las Vegas and throughout Nevada. I was having a conversation with the sales manager, Corey, about what can we do to help businesses in the Las Vegas area. And I came up with an idea, and he's doing it kicking and screaming because I want to make sure you as a business owner can have the best deal in advertising maybe ever made. So for this week only, Valentine's Day week only, if you call the sales manager of KDWN, and you've never advertised before, and you say, Corey, I love KDWN, he's going to give you an advertising deal like one that's never been done before. Do your business a favor. Call KDWN right now. 730-0334. 730-0334. If you've never advertised on KDWN before, never tried radio, call Corey today and say, Corey, I love KDWN, and see what KDWN can do for your business.
More live local talk than any station in Las Vegas. News Talk 720 KDWN. 50,000 watts of news and talk. Be in the know when you're on the go. News Talk 720 KDWN is available wherever you are online at KDWN.com. At KDWN.com. Local, national, and international news, plus weather and traffic, all at your fingertips, all online at KDWN.com. The broadcast of information on this show does not create an attorney-client relationship with any of the listeners. Communication between the listener and the hosts of this show will not be confidential. The information provided on this show is prepared for a general audience without investigation into the facts of each particular case and is not to be considered legal advice. The information provided on this show should not be used as a substitute for legal advice. The listener is advised to consult with a qualified attorney on any legal issue they may have. It's time for News Talk 720 KDWN's Legal Hour. Have a legal question? Call now 257-KDWN. That's 257-5396.
KDWN News Time, 9:06. Welcome to the KDWN Legal Hour Tuesday edition. Today, big topic, something you're going to be interested in, something affecting a lot of people in Las Vegas. 257-5396, the number if you have a question or comment. We have attorney Airene Williamson from the Williamson Law Office with us again, as we do each and every Tuesday. Airene, good morning.
Good morning, John. Glad to be here this morning.
Landlord tenant, those are the issues we're going to be discussing today, and they do affect a lot of people here in Las Vegas.
That's correct. It's a big topic to cover, and I'm hoping to get through all of this today. Basically, we're going to talk about the new law that was passed in 2011 regarding commercial properties and how to draft and prepare your leases. And the most highly emotional part of landlord tenant is obviously eviction. So I'm hoping to cover that today.
All right, 257-5396 if you have a comment or question. Let's start with that law, AB 398, that new law for landlord tenants in a commercial property.
That's right, and that's a very big law that was passed in 2011. Basically, the legislature thought that there should be a separate Nevada revised statute just addressing commercial properties. Before then, the only law we have is pertaining to residential properties, such as the NRS 40 for real estate law and NRS 118 regarding landlord-tenant and residential properties. But I think the legislature thought that there should be a separate law regarding commercial properties. They think that commercial landlords and tenants have equal bargaining position, and there should be a separate matter relating to them. And that's a very, very a lot of changes with that AB 398. It pertains to abandoned properties, basically, what to do when a property is abandoned, what kind of notices it should be given. And lastly, what happens when a commercial tenant is delinquent on their rent payment? And that's a big change with this commercial law.
So are there differences between a landlord and tenant in a residential property and a landlord and tenant in a commercial property that made them decide, we really need to have separate statutes for both?
Oh, definitely. I think the governing bodies and the legislature thought that in a commercial setting, there's a lot more equality between the landlord and the tenant. We're talking about tenants that are sophisticated businessmen, even in fact corporate entities that are tenants entering into a negotiated rental property or rental agreement with a landlord. So there's a lot more, it's a less strict provisions in an abandoned property. For example, the law is if there's a reasonable belief that a commercial property has been abandoned, then the only notice that a commercial tenant gets is a 14-day notice. That's all. It's different from a residential property wherein the residential tenant gets 30-day notice. And one of the biggest changes with the AB 398, which is now codified into NRS Chapter 118C for commercial properties, is what to do with an abandoned property. Is that you can store it and for 14 days, and the commercial landlord can basically sell it after 14 days, and then they can recover reasonable cost. And under AB 398, there's really no definition of what reasonable cost is. So theoretically, and we don't know how it's going to play out with the judges in town because this is such a fairly new law. But basically, in theory, the landlord can recover not only their cost of storage, but also the cost of rental arrears or any other costs that they've incurred in terminating the lease.
Wow. That
is a very big change.
That does seem like a lot.
And that's true because in a residential setting, and you can see it in NRS 118, the residential landlord could only recover storage fees. They cannot go after arrears in an abandoned property. So, but what I tell the landlord, a commercial landlord, is be careful when deeming a property abandoned because there's a 2008 Supreme Court case that came out where the commercial landlord made a mistake of deeming the property abandoned. It probably, the tenant probably just moved for a couple of days and they deemed it abandoned. They locked it out and caused some damages inside the property, and the court held them accountable for those damages. So be careful when you think the property is abandoned. Make sure you go through the notice, and we're going to talk about that shortly. What happens when a tenant is, in arrears on the rent?
So what is an abandoned property? I mean, I see a lot of vacant properties around Las Vegas, a lot of vacant commercial properties, but I wouldn't imagine they're all abandoned. Right. And the good stuff about AB 398 is it's as vague as it can get. So basically, if you have a reasonable belief that the property is abandoned, or in a commercial property setting, if you think that the goods and equipment there are substantially been moved, what does substantial mean? Well, it depends. In any question in legal arena, the answer is it depends. So you better talk to an attorney when you want to deem an abandoned property, especially in a commercial setting, because the value of the property in a commercial property is higher than a residential property. So be careful with that. And one of the biggest changes of AB 398 is actually how to deal with delinquency in rent payment. And basically this comes in the picture, in the arena of eviction. In the residential context, you cannot evict a tenant who is without notice, without an eviction order from the court. That is different from a commercial property. Nowadays, if a tenant is late on a payment, or let's say, for example, a restaurant is late on the payment on this property, all the landlord can do, all they have to do is post a notice for 5 judicial days on their door saying, I'm locking you out, I'm changing the keys. And after 5 days, if you don't pay your rent, then, you're basically evicted. And that basically forces the tenant to pay the arrears. And they don't have to give you out the keys unless you pay the arrears plus your current rent. So that is basically, you can see the framework or the mindset of the legislature when they passed this. And they were thinking that the landlord and the tenant is probably in an equal bargaining position. So there's a lot less protection for a commercial tenant. Yeah, it sounds like it. I mean, if after 5 days, the landlord could go and just lock the door on that restaurant, let's say, and then everything the people that own the restaurant own is locked inside, and it's too bad for them? That's correct. And in theory, that's how it's supposed to work, although I haven't seen it occur yet in a litigation setting. We'll see how it unfolds. But obviously, we have a new 2013 legislature. I'm not sure if it's going to be changed or if there's any suggestion of changes to this. But basically, they can lock you out within 5 days. If you don't pay, you're out. That's good for the landlord, probably not good for the tenant, but that's one of the biggest changes for AB 398. And then if you don't, as the tenant, pay your arrears, the landlord can go ahead and sell all of everything that was locked inside? Exactly. They have 14 days to keep whatever equipment is in there. They do have to give you a written notice to say, well, we'll keep it for 14 days. You got 14 days to get it out. If not, I can sell it and I can recover what they're calling a reasonable cost, whatever that means, or however the court interprets that. So basically, they have a lot of recovery for terminating the lease, at least for the landlord part. Yeah, it does sound like it. And definitely, I can see the difference between the commercial and the residential parts of it. It seems like a tenant in a residence certainly seems to have a lot more rights when it comes to things like that than a commercial tenant does. That's correct.
And that comes into play with, and I guess my next segue is the lease agreements and how you draft a lease agreement. And theoretically, basically, lease agreement, as we all know, is basically an agreement between landlord and a tenant with a rental property. But it's a lot more nuanced than that. In a residential leases, basically the governing bodies and the legislature thought that, there's a sanctity being in a residential property. And there's a lot more protection for the tenants. And so what they have placed in the law books are the NRS 118 and the NRS 40, giving the tenants these basic tenant rights in the residence, which we'll talk about a little bit more as we go.
All right. We are with attorney Airene Williamson from the Williamson Law Office. If you'd like to reach her at her office, 608-4072, or if you have a question for this morning, 257-5396. We'll be back more with Landlord Tenant rules and regulations here in Nevada. But first, we're going to check in with Mitch Kelly in the KDWN Nevada Credit Union Traffic Center.
And this update at 9:15 is brought to you by 99 Cents Only Stores. Kids always want to have the coolest Valentine's cards to share with their classmates, and 99 Cents Only Stores has a large selection of boxed Valentine's cards with popular themes for only 99.99 cents each. Save more and shop 99 Cents Only Stores first. Just one freeway accident remains, that on 95 northbound at Boulder Highway. For a time, it was blocking a right lane, and NHP now has it moved off on the right shoulder. No slowdowns from that. Leftover Surface Street crashes in the southeast, Maryland Parkway at Windmill and Pecos at Russell, west of I-15, Blue Diamond at D. Martin Drive, and on the west side, Rainbow just south of US 95 at West Cliff. Your next update's at 9:30, and from the KDWN Nevada Credit Union Traffic Center, I'm Mitch Kelly on News Talk 720 KDWN.
Hi, this is Jim Dallas of Beasley Broadcasting. For years, I tried to cover up my crooked teeth. Well, those days are now long gone after I went to see Dr. Miracondia and his staff at AQ Denture. In one day, AQ gave me a smile I'm truly proud of. Call AQ for an appointment at 565-6000. That's 565-6000. Dental problems don't have to hold you back anymore, and don't worry about the cost. AQ stands for affordable quality. AQ Denture, 565-6000. That's 565-6000 for AQ Denture. They'll restore your smile and your confidence.
Cracked radiator, $1,300.
Woohoo!
New brakes, $450.
All right!
Engine replacement, $4,000.
Sweet!
Why is Rick so happy that his car needs repairs? Because he doesn't have to pay for them. Rick has AutoAssure. Now he never has to pay another penny for expensive covered repairs because AutoAssure pays them for him. To join Rick and never pay for another covered repair again, call right now for free information. 1-800-700-0148. It's guaranteed protection. Keep your money, keep your mechanic. AutoAssure pays them directly, and you choose the coverage you need. If your car has less than 200,000 miles, you won't pay for any covered repair. Not for a transmission, air conditioning, suspension system, or anything else. Expensive car repairs?
Bring it on!
You don't have to waste your own hard-earned money on expensive covered auto repairs. Let AutoAssure pay them for you. Call now for your free information. 1-800-700-0148. That's 1-800-700-0148.
Now back to KDWN's Legal Hour. Have a legal question? Call now. 257-KDWN. That's 257-5396.
KDWN News Time, 9:18. Welcome back to the KDWN Legal Hour Tuesday edition with Las Vegas attorney Airene Williamson from the Williamson Law Office. 257-5396 if you have a comment or question for Airene while we're here in the studio this morning. We'll be here till 10 o'clock, so that only gives you a little more than 40 minutes to get your questions in. We are discussing landlord-tenant issues with Airene this morning, and I think we've covered the commercial aspect of it. Let's get into residential. I think that probably affects more people here in the Las Vegas area.
It does. And a little bit just kind of quickly in the commercial leases. The big difference between commercial lease and a residential, in a commercial lease, the landlord and the tenant has a lot more room to negotiate. Mm-hmm. It's not uncommon for me to negotiate a commercial lease that is 70 pages. That's typical for a commercial lease. There's a lot more clauses in there that are obviously not on a residential lease. In fact, a residential lease, a lot of landlords just get it from the internet, get what I call just a form agreement. And most of the time that works, but it doesn't eventually if there's a dispute. But in a residential setting, the idea is that the tenant is not in equal bargaining position as the landlord. So basically the legislature has put up all these laws to protect the tenants. So in case there are provisions that are not on the agreement, the NRS can still protect the tenant. This is not so in AB 398 for commercial, which means even though there's new laws in the AB 398 for abandoned property, for notices and evictions, ultimately the lease agreement in a commercial property will prevail. That is not the same for residential. Ultimately, what will prevail is the NRS Chapter 118 for residential properties.
All right, Irene, we have a phone call for you here this morning. Steve is on the line. Good morning, Steve.
Good morning, John, and good morning, Irene. How are you today?
I'm doing well. How are you, Steve?
Good. I appreciate your good advice. I have a question for you.
Sure.
On a short sale, normally, once the short sale is completed, I heard that the people, my friend is staying at the house just temporarily, he's served with a 3-day notice to vacate, and then they have 20 days to respond to the 3-day notice. Is that correct? And then it goes to the court, and then they decide when the people have to be out. Is that normally, if someone doesn't have a lease, they're just staying there kind of at will?
These people are tenants, or what's their situation in the property?
I let him stay there. It's a good friend of mine, so I'm not charging him. He's just staying there, basically to have a place to live until the sale is over. That's all. No legal contract. I'm just, letting him have a place to stay.
To be honest with you, Steve, they don't even have 20 days to answer. It's typically when in a foreclosure setting or a short sale, if the occupant is not a bona fide tenant, they have 3 days to get out. And the 20 days is just basically out of the goodness of whoever is the successor interest gives them.
To leave. So it's 3 days once they're served with the notice. Okay.
Right.
If they negotiate, but here's the problem. Most of the people that are investing money want them out of there as soon as possible.
Yes.
They don't want to wait. So they might be able to get a few extra days, but not much more than that normally under normal circumstances.
That's correct.
So they will be served with a 3-day eviction notice. Is that correct?
3-day eviction notice. Basically, it's going to be a summary eviction, which I'll talk about more in detail later. And the judge will order the eviction. The eviction will be forwarded to the constable. The constable will have 24 hours to get him out.
Oh, I see. So it happens that fast. With a 3-day
happens
notice.
that fast.
Let's say, okay, they answer the notice on the 3rd day. By the 4th day, the constable will usually be there. Is that correct?
That's not sure. That's not so correct. What people do is that they can have the opportunity to answer. And when they answer the eviction notice, that's typically a strategy to delay any eviction in any setting. So when the landlord or whoever successor in interest posts a 3-day notice, then you have the opportunity to answer. And when you answer in court, the court will hold a hearing, which actually gives you guys time to move or make arrangements or what have you. And that's a good, it's a good strategy to delay, and people use that.
Got some medical issues, Irene. I don't want to see him get thrown out on the street too quick.
Right.
The normal median time for the answer to the court and all that, like let's say the landlord, in the worst case scenario, wants to get him out of there as soon as possible, will probably be a few weeks. Is that correct?
That's correct. Maybe a week. So that's a 3-day notice. There's an answer, and the court will hold the hearing as soon as possible, depending on their docket. 2 weeks at the maximum.
Oh, I see. In other words, it could be up to a week before it gets into court.
Right. That's if they answer. If there's no answer, 3 days, Steve.
Okay, no answer, 3 days. Okay.
Right.
All right, and thank you very much. I really appreciate the good information you're giving out there, and let's hope you have a wonderful day.
You too, Steve.
Thank you.
Thank you, Steve.
And I want to comment on that. And when it comes to short sales and foreclosure, and I may not be able to get through all that today, but when it comes to a foreclosure, if you are a tenant and your house is and your landlord, who's the previous owner of the house, is being foreclosed, be careful with that for people that are successor interest, either whether you're a bank or you're a new owner, or sometimes in the context of an HOA who is foreclosing on a house because they're late on their association fees and they're foreclosed on a house. Be careful when you evict a tenant, because there is an act that was enacted in 2009. It's called Helping Families Save Act, which provides a different notice. It's mostly, if you're not a bona fide tenant, it's 3 days. If you're a bona fide tenant, which means you have a valid lease and you got there on a valid negotiated lease, you have to have a 90-day notice to get them out. So that's a lot of time, either 90 days or the length of the lease, whichever is longer. So be careful when you're doing an eviction on a foreclosed house.
And I imagine if you're a renter and going to rent a residential property and you know that it's going to be in a foreclosure or short sale, make sure you have a lease so that you're not tossed out.
Exactly.
Like Steve's trying to help his friend out, but in the end, it might end up that Steve's going to have more house guests than he thinks in his own house.
That's correct. That's correct. If you don't have a bona fide lease, they can kick them out. And I always have that problem with tenants who, for previous owner who has basically transferred the house to their children or their friends. Well, I have a friend there, but he's not exactly a tenant. Well, he's not there. Those people are not protected under this act. It only protects bona fide tenants.
What about a verbal lease? So would a verbal lease work, or is even a lease that you just pulled off the internet better than just a verbal lease?
If it's a choice between a verbal lease and an internet pulled out agreement, I would go for an internet pulled out agreement. And it's not that verbal lease is not valid. In fact, NRS 118A160 allows for a verbal lease. But we have to keep in mind there's this legal principle called statutes of frauds. Basically, it means that any contract that is not signed under certain situations will not be valid. And that includes conveyance of real estate properties or interests, which means rental, that is over a year. If it's over a year, it has to be in writing. It has to be. Otherwise, it would not be valid. If it's less than a year, like month to month or week to week, theoretically, you don't have to put it in a verbal agreement. But I've had litigation because people do not put it on in a written agreement, and it's going to be in a he says, she said situation. And the course will have to go through the process and take evidence, and that's certainly a longer process than if the parties have had an agreement in the first place.
Yeah, I don't know why you would, unless it, again,
it happens,
is with a
John.
friend. Yeah, I'm sure, but I don't know why. If I was renting out a property to a total stranger, I don't think I would just have a verbal agreement with them.
That's correct. And just keep in mind, in a residential setting, even if you don't have a lease agreement, we do have the NRS that has the basic rights that protects tenant and as well as the landlord if certain provisions are left out if they didn't have an agreement at all.
So what should be in my written lease? Because I don't know anything about this. I just happened to have some money laying around. Real estate was cheap. I bought an investment property. Now I want to rent it out. I don't know anything about being a landlord.
Right. Well, it's different in situations to situations, especially, if you're in an apartment, you got to be careful. And usually if you're in an apartment, there's property managers that help people out for an agreement. If it's a residential, people will just pull out agreement from the internet. But at the ultimate basic, you should have at least provisions about what's the term of the tenancy. Is it fixed? Is it a year? Is it month to month? What is the amount of the rental? What's the security deposit? The security deposit, as I'll talk about later, is a highly disputed area of landlord tenant. So it has to be there somewhere. How are you going to deal with it when a lease is terminated? What is the notice for termination? What happens when somebody abandons the property? What do you do with abandoned property? And one of the areas that I want you guys as landlord and tenants to address is what to do with repairs. Repairs is such a big thing. Who does the landscaping? Who does the pool? Who repairs what? Who pays for the utility? Is the landlord responsible for electricity while you're responsible for water? Who's responsible for the HOA fees? Those are just stuff that you need to talk about and put in a lease agreement.
Right, because those are things I could see how I would just assume I'm renting out the property, so they're going to pay the electric bill, but they might assume, well, you own the property, you're going to pay the electric bill.
Exactly, and that often comes up in an HOA arena where the tenant thinks the landlord is paying for the HOA because the landlord is the owner of the house, so the HOA is assumed to be paid, but unless it's in writing, you better clarify that.
Well, there's a lot that goes into it.
It does. Definitely.
I can see why getting legal help on this would be the best way to go.
It would be the best way to go, especially if you have a lot of properties in town that you're renting out residential-wise, because residential-wise is a lot of restrictions and laws that come with it and obligations to come with it. You better make sure you know what you're doing and you clarify that either with an attorney or with a property manager, basically, and especially with a commercial setting, that becomes a highly, it's important to go through that with an attorney.
What kind of trouble could I get into as a landlord if I just plead dumb? I didn't know that's what the state law was when I did such and such to my tenant.
Well, damages for one, and this comes up in two ways. There's two ways that landlord gets in trouble for, and because in NRS 118, you do, as a landlord, have basic obligations, and one of them is providing habitable living and providing essential services. And if you don't provide those services, which I will talk about later in more detail, you will be liable for damage. In fact, in 2009, they passed a new law that if you fail to provide essential services, we're talking about gas, electricity, heat, and I can't tell you how many landlords failed to provide those services. You can get damages up to $2,500.
Wow. We will be back with attorney Airene Williamson from the Williamson Law Office discussing more on the tenant-landlord issues here in Las Vegas and in the state of Nevada. 257-5396 if you have a comment or question. Right now we're going to check in with news, traffic, and weather on News Talk 720 KDWN.
can't sing. I reached out, trying to love, but I feel nothing. Oh, my heart is numb.
What you hear isn't just any beat, it's the actual heartbeat of a child in need. This is Ryan Tedder from One Republic. The beat of our new song, Feel Again, was created with heartbeats of children in need. Find out how it can help frontline health workers save millions of children at everybeatmatters.org.
Brought to you by Save the Children and the Ad Council.
50,000 watts of news and talk. News Talk 720 KDWN, Las Vegas, the dawn of today's talk radio.
AP Update. I'm Rita Foley. There's lots of talk about what the president will and won't say during tonight's State of the Union address. Our Mark Smith is at the White House, where he's been talking to the insiders.
He'd say the president's speech will center on the economy. On NBC's Today Show, advisor Valerie Jarrett said jobs require investment.
He will demonstrate concretely how we have to invest in manufacturing, making the United States a magnet for job growth.
However, foreign policy will also be featured, with Obama planning to denounce North Korea's latest nuclear test and to announce 34,000 U.S. troops will leave Afghanistan within a year, roughly halving the U.S. force as America's longest war draws to a close. Mark Smith at the White House.
Many House members have invited guests who have been hurt by gun violence. A Texas congressman has invited rocker Ted Nugent to tonight's speech, a longtime gun control opponent. AP Update. I'm Rita Foley.
9:32 in the KDWN One Nevada Credit Union Traffic Center with an update brought to you by Binion's Gambling Hall. New problems in the downtown area. An injury accident 95 southbound at Las Vegas Boulevard. And we've got backups all the way to South Rancho on 95 southbound right now. New one also in the Henderson area on the College Drive off-ramp from 95 south. Earlier one 95 northbound at Boulder Highway. That off on the right shoulder getting ready to be cleared away. KDWN weather, sunny skies at a high of 56 this afternoon. Currently 43 degrees in Las Vegas. More of the KDWN Legal Hour with attorney Airene Williamson's coming up. On the KDWN One Nevada Credit Union Traffic Center, I'm Mitch Kelly on News Talk 720 KDWN.
Rediscover good food at Binion's. Benny's Bullpen now has a Chicago-style 10-inch cheese pizza made to order for just $3.49. Visit Benny's Bullpen today. Binion's, good food, good whiskey, good gamble.
I'm Kent Davenport of Quality Hearing Aids. The only way to stop a bad guy with a gun is a good guy with a gun, and I know how to put an armed guard in every school in the country at no cost to the taxpayers. Deputized grandfathers. There are tens of thousands of grandfathers, retired police, retired military, or otherwise experienced shooters, and every one of these men that I have talked to tell me they would happily provide their own weapon, buy their own uniform, attend any training, and volunteer without pay a few days a month at a local school. Most of them have already been investigated and fingerprinted to get their concealed carry permit. They would just have to be deputized as reserve officers by local law enforcement. Help me spread this idea any way you can. Kent Davenport, Quality Hearing Aids, 369-1321, 369-1321.
24/7 private vault. Better than a bank.
Mr. Elliott at 24/7 Private Vaults. You need privacy today. Anyone that wants to start a lawsuit with you has your name and your social security number. At 24/7 Private Vaults, it is totally private. Call me at 948-5555. That's 948-5555.
24/7 private vault. Better than a bank.
NASCAR is back. Las Vegas Motor Speedway wants to celebrate with its biggest fans.
Join us February 24th at the Stratosphere for some great prizes,
including neon garage passes or Cobalt toolkits while you watch all the Daytona 500 action. It's a Daytona 500 viewing party with Las Vegas Motor Speedway at the Stratosphere. Enjoy great drink specials provided by Budweiser and a chance to win tickets to the Cobalt Tools 400. Visit lvms.com/Daytona for more details. See you February 24th. Now back to KDWN's Legal Hour. Have a legal question? Call now. 257-KDWN. That's 257-5396.
KDWN News Time, 9:35. Welcome back to the Tuesday edition of the KDWN Legal Hour with Las Vegas attorney Airene Williamson from the Williamson Law Office. 608-4072, Irene's number at her office. You can also reach her by email at info@wlawoffice.com or check her and her office out at wlawoffice.com. That's their website. If you have a question or comment for Irene this morning, 257-5396. We've been discussing landlord-tenant issues. We went over the commercial property issues. We're now dealing with residential landlord-tenant issues. So if I'm a landlord and I lease my property out to a tenant, does that tenant have to live there? Can somebody else live there? Who can live in that premises?
That's a good question because, as we know, a lot of people are probably having their relatives live in their houses without the landlord's permission. But basically, and I think everybody knows, whoever is on the lease will be the ones who have rights to be on the property, including their minor children, or if any children is born or adopted to that family, they automatically gets to stay there. But it will depend on three areas. One is the lease, who can live there, and one is the Clark County zoning, which I think allows for a single family, immediate relatives, plus 3 additional unrelated individuals in there. And the last one is the HOA rules. So it will depend on how many number of people that is allowed by the HOA, by the Clark County, and by the lease.
So while you have certain state regulations, which are the same across the board for everybody to follow, every HOA is different. There's got to be so much to know if you're going to lease out a property.
Well, the general rule is the state can put the number of people that can live in a house. The HOA can be stricter, but they cannot be more liberal than the state. So HOA can, narrow down how many people can live in a house, but they can't expand as large as or as more than the state. That's the general rule.
And I'd imagine it would be between you and the tenant as well, if they're allowed to then sublease the property out, or if they have to terminate the lease and you can lease it out again.
That's correct. And we're careful with subleasing because subleasing is actually not common for residential properties. So that's something that has to be negotiated between the landlord and the tenant.
All right, we've got some phone calls for you, Irene. Let's get up here. The first call is Dave. Dave, good morning.
Hi, good morning. How you doing?
Hi, Dave. Good morning. How are you?
Good. Hey, my question is, I owned a home here in town for a number of years, and I was just recently foreclosed and did a Chapter 7. And I'm staying with family right now, but I'm looking to rent about the 1st of April, and I'm just wondering how that's going to affect my rental as far as, being able to get a house, because I'm looking for a house, and also what I should look for in a lease, because I've never rented before.
Are you talking about, or I'm assuming your role will be a renter? Well, 2 things. I have to be frank with you, Dave, is that foreclosure and obviously bankruptcy will show up in your credit report. Sometimes residential properties, especially apartments, will pull your credit report, and it may or may affect your ability to rent a property. But obviously, a lot of people in town are, they have a lot of history of foreclosures, a lot of history in bankruptcy. So on that matter, it may just be a matter of negotiating maybe a higher security deposit, a higher rent. So it doesn't completely preclude you from renting a house.
Okay, yeah, because I'm not looking at apartments. I need to rent a house.
And actually, when it comes to housing, they're even less strict than apartment because apartments are oftentimes ran by property managers who are by the book. These landlords that rent out houses, they just want the houses rented. In fact, I know some friends in town who are renting their houses, and they're not really looking to your history of foreclosure. They just look for one thing, is that if you can pay your rental, which is a regular income, if you have that, then and is in a good security deposit, that's all they're looking for.
Okay, great, because I have a good income now, and I have cash set aside for that. So,
right.
And what main things as a renter, because I've never rented, should I be aware of in a lease that I should ask about?
Well, the 2 things that are, oftentimes people come to me is 2 things. Who does the repair of the house, if there's anything that goes wrong in there? How you terminate the lease if you have to leave, and when you have to provide notice, because that's usually a good question for tenant is, I don't want this house anymore. When can I leave? Well, it depends on your termination clause. So look for that, and the repairs. And lastly is the security deposit. What happens when I terminate? Do I get my security deposit back? Well, it will depend on your rental agreement.
Okay. Well,
all right.
Thank you very much.
Thanks, Dave.
Thank you, Dave. We will move on here to Frank. Frank, good morning.
Yes, it is. It's a beautiful morning here in the Southwest. Irene.
Yes.
Something has troubled me and has put me off about the country in general. A personal friend, we're going back 3 or 4 years. when it appeared times were still good, even though it was clear they were going bad, he got promoted to terminal manager, which is big.
Right.
And we're talking about a hub of a trucking company, and he had his credit was perfect, everything was perfect, and he told his girl, I'm gonna, he moved, very conservative. He moved out of a comparatively bad neighborhood, went to Summerlin, went to this rental. It was apartment. Well, it had everything, and it was like, wow. And they told him, we see an assault. It was like 25 years ago, and his crime was defending himself in a fight. But how did they find that? This is Social Security, and then they disallowed him. His credit, everything was right, and they went back 25 years and saw that he had a fight and didn't even take his point of view.
So was he evicted? Is that what you're saying?
No, he wasn't even allowed to move in, allowed to rent.
Yeah.
I mean, how did they find that? And I mean, this was mind-boggling to me.
Right. Well, two things to that, Frank, is one, they can absolutely find that. It's in a docket report in the courts. And unfortunately, discrimination is only limited to, as you probably know, Frank, race, color, and all that. And that's set forth in NRS 118B for discrimination landlord tenant. As far as criminal record, unfortunately, landlords can choose and pick who they can have renting their houses, especially when they have an assault. And I'm sure your friend is probably an exception to this, and this is a long time ago. But the problem is, on a landlord perspective, if they know of an assault record, and if it happens again, and if it's for some unforeseen reason they assault somebody in that property, either a tenant or some other people living in there, then the landlord, especially in an apartment situation, can be liable because now they're on notice that this person has an assault record before. And obviously that's unfair because this is probably going back when he was young, and this is probably nothing to do with his present situation, but they can definitely discriminate when it comes to criminal record.
All right, Frank, thank you very much. We will move on here to Jerry. Jerry's got a question for you, Irene. Good morning, Jerry.
Good morning.
Good morning, Jerry.
Irene, I live in a residential area. I live in a seniors complex.
Okay.
And I've lived here for about 4 years now. But anyway, just recently, apparently the owner decided that we were getting too much water pressure in our showers and in our kitchen sink. So they cut back on the water pressure. Now it takes about 10 minutes for the face bowl to fill up with hot water in the bathroom.
You said hot water?
Yes.
Okay.
And not only that, the hot water is intermittent. Sometimes it's hot water, sometimes it's warm water.
Right, right.
I mean, isn't there something that says that if I'm supposed to keep this place in living order, they keep their end of it up that way?
That's correct, Jerry. And I was going to talk about habitability, which is under NRS 118A. Part of the habitability provision is that they have to give you a working water supply in good working condition, plumbing facilities, and all that good stuff. And if you don't have that, Jerry, I think there's two steps to do. And one is to give them, and I don't know if you've already done this, is to give them a written notice to fix the problem. They have not necessarily, and you know what, this could be a fine line between an essential service and an habitability service, but that's something I need to know in more person, maybe talking to you on an in-person consultation. But you have to give them written notice of the problem. And if it's a habitability issue, they have 14 days to fix it. If it's an essential service, which is you're not getting hot water at all or cold water at all, then they have 48 hours to fix it. If not, you can have it repaired and charge your landlord back. You can terminate the lease if they don't fix it, or you can go to small claims and have your damages compensated. There are different ways to do it. But yes, you are correct. There are protections for habitability.
Well, it's not just my apartment. The entire complex. They have like 62 acres of, like Adobe-like buildings here. And they've done it to everybody. I mean,
that's even more egregious than what I thought. So definitely, you and the other persons living in the property have the right to at least provide them a written notice, give them an opportunity to cure the problem, and if not, then you definitely have different ways to resolve it.
Okay, thank you very much.
Thanks,
Jerry.
Thanks.
All right, we will be back for our final segment with attorney Airene Williamson from the Williamson Law Office discussing landlord tenant issues right after we check in with Mitch Kelly in the KDWN Nevada Credit Union Traffic Center.
And at 9:45, an update brought to you by Firestone Complete Auto Care. Renew your ride with a new set of tires during Firestone Complete Auto Care's February tire event. This month, buy 3 and get the 4th free on Firestone Champion HR high-performance tires for your vehicle. Call 1-800-LOCATE-US to find the store nearest you. Together, Firestone will keep your car running newer, longer. Big slowdowns pushing through the downtown area. The problem, an accident 95 south at Las Vegas Boulevard, and you're slow back to before the Spaghetti Bowl because of it. Staying on 95 southbound, a crash on the College Drive off-ramp from 95 south, and a new one also reported 15 southbound at Sahara, but we're not seeing any significant slowdowns from that crash. Just leftover wrecks on the surface streets in the southeast, Pecos at Russell, west of I-15, Blue Diamond at Dean Martin, and on the west side, northbound Rainbow off of US 95. Your next report's at 10, and from the KDWN Nevada Credit Union Traffic Center, it's Mitch Kelly on News Talk 720 KDWN.
Do you have hidden treasures laying around your house? Hi, this is John Burnett of Las Vegas Jewelry and Coin Buyers. Join me on Ask the Experts every Monday night at 6 p.m. on News Talk 720 KDWN, where we will discover valuables you have that you can convert to cash.
Are you tired of fighting with your water, dry skin and hair, dingy laundry, unpleasant tastes and odors, stained sinks and fixtures? Well, now is the time to do something about your water. Hi, Alan Stock here, and I wanted to make sure I had the best water system available, so I called Connecticut over 13 years ago. My clothes are brighter, I see no more hard water stains, and the water is the best I've ever tasted. As a matter of fact, people who visit our home always ask for another glass of that delicious water. And the amazing thing is, we haven't had any service calls to fix our system. Now, the experts at Connecticut Water Systems really know their stuff and can customize a solution that's right for your home and your family. Now, the Connecticut Water Systems are completely different. They require no electricity, there are no customer adjustments, and they don't use a ton of salt. Connecticut Water Systems also features the longest manufacturer's warranty, and it's designed to last 30 years plus. Your local independent authorized Connecticut dealer wants to make it as easy as possible for you to try clean conditioned water in your home by offering a free trial. Go to kwater.com for more details on their free in-home trial. That's the letter K and the word water. kwater.com and get your trial started today.
Hi, I'm Ray Lucia. You've heard people calling my radio show concerned about skyrocketing long-term care costs, and rightfully so. A private room in a long-term care facility costs about $80,000 a year. This according to the American Association for Long-Term Care Insurance. The longer you live, the more likely you are to need care. So what can you do to prepare? Let me introduce you to Lynn Rowe, certified financial planner, whose expertise is long-term care insurance. Lynn understands exactly where a long-term care policy can fit into your retirement plan. Lynn works with people across America to get the protection they need, and you need to take action now. If you're younger and in good health, you have a better chance to be eligible for preferred rates. Call Lynn Rowe, CFP, at 800-644-1128 for a free consumer guide to long-term care or a complimentary consultation. 800-644-1128, or visit Lynn's website, iwantmyltc.com. That's LTC as in long-term care. iwantmyltc.com.
Miracle Mike's Memories.
The Miracle Mike Show.
Nostalgia, baby. The Beatles to Bogey. Stress relief. It's all fun. Saturday night at 9 on News Talk 720 KDWN.
Now back to KDWN's Legal Hour. Have a legal question? Call now. 257-KDWN. That's 257-5396.
KDWN News Time, 9:49. Welcome back to the KDWN Legal Hour with Las Vegas attorney Airene Williamson from the Williamson Law Office. 608-4072, Irene's number at work. You can reach her by email as well at info@wlawoffice.com. Discussing landlord tenant issues, and Airene, you've talked about this with some of the callers, and before that as well, security deposits, and what a big deal that is to have written in your lease.
Right. And mostly I get questions from tenants regarding how to get back their security deposit, and one of the questions is, do the landlord have the duty to give it back to me? And the answer is not necessarily. Security deposits, when it comes to security deposits, the landlord don't have to necessarily return it. They can deduct the security deposit that you have given when you entered into a lease, either to remedy rental arrears that you haven't paid, or to fix any damage in the house that is not part of normal wear and tear, which I'll discuss a little bit in a little bit while, and any cost of cleaning in the premises. And I guess the question is, what is normal wear and tear, and what can they deduct on my security deposit. It's a little bit hard to determine what is normal wear and tear and damages, but I like to give my clients examples, or when I do these classes on Landlord Tenant, I like to give examples of what's normal wear and tear. And one of it is if the carpet is worn thin from use, that's normal wear and tear.
Mm-hmm.
But if there's stains in there from pets or leakage in the fish tanks, that's damage. Most likely it's damage. Or when it comes to tiles or bathroom tiles, if there's stains in the bathroom tiles, that's probably normal wear and tear. But if there's broken tiles caused by the tenant, they can deduct the security deposit from that. Another one, my favorite, is picture holes. Picture holes, nicks, little nicks in that. Probably normal wear and tear, but there's gouges and holes, and I've seen punch holes in the walls. Those are damages, and they can absolutely deduct that from their security deposit.
Before pictures, is that a good idea? Either as a landlord or a tenant, take pictures before you move in, and then you have them?
Absolutely. And it seems like it's a common sense to do this, but not a lot of people do it. Obviously, in a more sophisticated property, like apartment, they do have a list that you need to go through, and I advise you to go through it and see if there's any substantial damages in the house. Take pictures, because if it comes to dispute, believe me, it will come up, and which one is damaged by who, and that is an important matter to discuss. And when it comes to security deposit, once you terminate the lease, the landlord will have 30 days either to give you your security deposit back or give you an itemized accounting of what he wants to take out of the security deposit. So they have 30 days to do that. And if they don't, then the tenant will now have a recourse in small claims court to file to get their security deposit back. And the important thing to remember is that the tenant can actually get double damages for security deposit that is not returned within 30 days. So landlord, be careful. If you don't want to return a security deposit for some damage, you at least have to give a 30-day written accounting of what do you want to take out, because they can get double damages. And I've been successful in getting that double damages in the past.
Yeah, everywhere I've ever rented has been an apartment complex, and like you said, they all have property managers. I knew what was spelled out. If I was going to get my security deposit, I could get the whole thing back if I didn't mess the place up at all.
Right.
And it was always 1 month's rent.
Right.
How do you determine what is a right security deposit?
That's a good question. In a commercial setting, obviously that's negotiated between the parties. In a residential arena, there is limitations under the NRS. For private housing, it's no more than 3 months rent. But obviously, in this competitive market, 3 months rent for security deposit is really high, and usually the landlords will work with you in a security deposit, either 1 month's equivalent of rent or no security deposit at all, which I've seen. In a Section 8 housing, I believe it's either no more than 1 month's rent or $50, whichever is more. And on a public housing, no more than 1 month's rent. But in a private housing, definitely 3 months is the max. And I haven't seen that in a long time, especially in this market when we're saturated by rental properties.
Right now, I've bought a property. It's an investment. But now there's hardly any real estate here for people to buy anymore. And I get an offer I can't refuse, but I've rented out my property. Can I sell it out from under the person who's leasing it from me?
Sell it how?
I'm going to sell it to another party that wants to buy my house, but I have a tenant living in it.
Oh, boy. Well, you can, but you do have to provide your tenant a notice either when they enter into an agreement with you or especially in the case of a foreclosure, because if there's a foreclosure on the house or you're selling the house and you're not telling your tenant that this transaction is going on, they have placed protection back in 2009 that you can now be liable for deceptive trade practice. Unfortunately, when it comes to foreclosure, the tenant comes to me and say, the house is being foreclosed, and the landlord never told me it was going to be foreclosed. Now they're evicting me. Can I go after the landlord? And theoretically, yes, under Deceptive Trade Practice Act. But in practicality, the landlord is gone. They probably don't even have any assets to go after anymore. But just on a foreclosure matter, just be careful and just be mindful of the notice that the successor in interest gives to you or posts to your house, and see if you have rights under the Helping Families Save Act in 2009.
And since you brought up eviction, what sort of rights as a tenant do I have? I would imagine my landlord can't come to me and say, I need you out tomorrow.
Yes, that's definitely correct, especially in the residential arena. In any eviction for residential, they have to go through an eviction notice. And that will depend on what kind of situation you're being evicted on. If it's a non-payment of rent, it's usually called a summary eviction. Very easy, very fast, 5-day notice. And then the court, if there's no answer from the tenant, usually there isn't, because there's a lot of places to rent out anyway. The tenant just leaves. But it's just a 5-day notice. The court issues the eviction order, forwards to constable, you're out in 24 hours. If it's a nuisance or violation of unlawful business in the house or any damage to the house, you got 3-day notice to fix it. And then the landlord would have to give you another 5-day notice if you don't respond. And then if no response at all in that 8-day span, then eviction. For no cost eviction, it will depend on, if you just want the tenant out, it will depend on how long their periodic rent is. If it's month to month, then it's 30-day notice. If it's weekly, then it's 7 days. If it's a year-to-year lease, it will depend on the lease agreement. So in any case, there will have to be some sort of an eviction notice, some form of you as a tenant to file an answer in court. And be careful, landlords, when you are posting your eviction or serving your eviction, there are ways to serve it properly. If you don't serve it properly, then you will have to redo your notice. And be careful what you put in the notice, because with a 2011 legislature law, they have added certain languages that you now must have in your notice. And if you don't have it, it will be an improper notice. So in any case, eviction notice goes to court. The tenant will have a opportunity to answer, and if they answer, it will delay it, but there will be a hearing, and if it's meritable, then an eviction will be completed.
And then the tenant gets angry and destroys the inside of the property as they're moving out. Do
Yes.
I then have any recourse as the landlord? Because if they haven't been paying the rent in the first place, again, they don't have anything for me to go after, most likely.
Well, that's the practical truth of the matter, but usually landlord-tenant disputes are litigated under either in small claims if it's $7,500 or justice court if it's above $7,500. But definitely if there's damages in the house, again, you can either take it out of the security deposit, give them a written itemized accounting of what you're taking out, or go to small claims court or justice court and file a lawsuit. The problem is, first of all, can you even find the tenant after they move out? And second of all, I always do an asset search first for the tenant before we even spend this money going after somebody who doesn't have any assets at all to pay you in the end, and you spend all this money. And sometimes you just take it out of security deposit and rent out the property and move on.
As an individual person, not a property manager at an apartment complex, if I just had a single property I wanted to rent out, how do I go about doing a check on any tenants that might want to move in, just so I can make sure there isn't any problem that has happened in the past, like they haven't been evicted from another property and are just moving to me next?
Right. And when the economy was relatively good, people often pull a credit report. I mean, that's pretty easy. And that's part of the rental agreement fee, where you can give a fee to pull a credit report. And I have to tell you, as a landlord, you do have a duty to, at the minimum, see, especially in apartment properties, if they have any history of criminalities, assault. Obviously, you want to see if they have any evictions in the past. Those are the kind of background check you can do.
All right, Irene, next week, what are we going to talk about?
We're going to talk about internet defamation. I think with the advent of Facebook, Twitter, and all these social media, it's been really great for us to connect with families and colleagues, but it's also been an opportunity for a lot of people to post negative comments on businesses and individuals. And we're going to talk about what you can do and how do you fight those negative comments.
All right, next Tuesday, 9 o'clock, with attorney Airene Williamson from the Williamson Law Office. You need to get a hold of her before then, 702-608-4072, or email at info@wlawoffice.com. Irene, thank you.
Thank you.
If you're in trouble with the IRS, there's 2 words you need to know. Robert Wagner. Wage garnishments, penalties, back taxes, nasty letters. Robert Wagner can cure your troubles. Robert is an enrolled agent licensed by the IRS and knows how to get it done. When Robert represents you, he can help you with any tax problem you have right now. Let Robert get you some tax relief. Call Wagner & Associates now at 564-1040. Don't face the IRS alone. Call 564-1040 or go to robertwagnertax.com. 564-1040.
NASCAR is back. Las Vegas Motor Speedway wants to celebrate with its biggest fans. Join us February 24th at Sam's Town, Suncoast, the Orleans, or the Gold Coast for your chance to win NASCAR and Las Vegas weekend tickets, including Neon Garage Passes or Cobalt Toolkits, while you watch all the Daytona 500 action. It's a prize-winning Daytona 500 party with Las Vegas Motor Speedway starting at 9 a.m. on February 24th at Sam's Town, Suncoast, the Orleans, and Gold Coast. Enjoy Budweiser drink specials and a chance